All right, good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Monday, April 8th, 2024. We're going to be working off of voting list number 30. Sine die.
Do you want to start with the concur?
I'm going to start off with concur, not concurs.
Senate Bill 46, as passed by the Senate, establishes that a contract for sale of a condominium unit is unenforceable if the contract does not contain specified notices related to the presence of asbestos. As amended by the House, the bill replaces language of "in the site" to "in the condominium." This bill is cross-filed with House Bill 143, which passed the Senate unanimously with just that difference. This is a reconsideration of a concur, not concur request. The House asked us to revote on whether to concur or not concur. The House bill had the missing language that we sent over without it. The Senate bill is in the correct form, which is how it was agreed upon by all the stakeholders. So the committee may reconsider the concur or not concur.
It is. Sandy, tell me if I get the motion wrong here, but I think the motion is to reconsider the vote by which we decided to concur or not concur.
Yes.
Okay, and now I make a motion to concur with the House on the Senate bill. Is that the correct motion, Shamari?
Yes.
Okay.
Senate Bill 413, as it passed the House, or as it passed the Senate, prohibited discrimination and essentially made military status a protected class. The House amended the bill to just prohibit discrimination in housing and employment. And we voted the House bill out with those. We voted the House bill out favorable with those modifications. So the motion would be to concur.
Motions to concur with the House version. Second. Is everyone okay? All right, excellent. All right, so House Bill 947, can you just refresh our memory?
Yes. Gun Industry Liability Act. So this is the House bill. You want me to explain the House bill? Okay, so the House bill 947 prohibits a firearm industry member from knowingly creating, maintaining, or contributing to harm to the public through the sale, manufacture, distribution, importation, or marketing of a firearm-related product by engaging in conduct that is unlawful or unreasonable under the totality of the circumstances. It requires a firearm industry member to establish and implement reasonable controls regarding the sale, manufacture, distribution, importation, marketing, possession, and use of the firearm industry member's firearm-related products, and establishes the violation of these provisions as a public nuisance. In addition, the bill authorized the Attorney General to bring an action against the firearm industry member for public nuisance caused by a violation of the bill's provisions as specified. The bill also requires the Attorney General, in consultation with the Department of State Police, to conduct a specified study related to firearm trace requests and report its recommendations and findings to the General Assembly by June 30th, 2025. The bill's provisions are severable. The bill takes effect June 1st. The House added an additional amendment to allow a county or Baltimore City solicitor to bring an action under the bill as specified.
There's a motion for favorable as amended. I'll second it.
would just be
It would just be favorable. Yeah, sorry. It's straight favorable. Yeah. Go ahead, Senator West.
So as I recall, the Senate bill, we narrowed considerably. We limited these actions only to the Attorney General. So the House bill expands that and lets city solicitor and county solicitors file actions too. Well,
Yes.
I think you can find some of us are going to vote no. So we need a roll call vote on this at the very least, but I just want to make sure everybody understands what's going on here.
Yeah.
So will this amend the Senate bill as well?
We're not in possession of the Senate bill. The Senate bill is on third reader in the House right now. We have the House version.
And are they going to amend?
They're going to keep it the same as they're going to keep it in the House posture. So they've amended the Senate version to look exactly like what we have here before us right now. Senator Folden.
I apologize. I had to step out and take a call. So this is now going to be, so it's going back to the original language that was in our bill?
No.
So who's able to, so the Attorney General can then now still have the authority to sue anywhere, any manufacturer, dealer, anybody, right? That sells these.
Sorry. What they've done, what the House did is they added the city solicitor in Baltimore City and the county attorneys of the other 23 jurisdictions.
And they don't even have to do it with a plaintiff. They can do it on their own accord.
Could, or a citizen could file a complaint with their office.
Yeah, I mean, that's one thing, but that's entirely different. So this one, they can just do it on their own. So in theory, you could have the Attorney General, the city solicitor of Baltimore, file suit at the same time against a gun dealer in Montana. And with state resources, without a complainant other than themselves, could then move to move forward with a lawsuit against them.
Quick question, because I think that it could also be more expansive than that. Could it not also be that if the manufacturer is deemed to be a nuisance across the state, it could be the Attorney General, the city solicitor could join in with the county attorneys. It could be, everybody could kind of file their joint claim as joint plaintiffs, correct?
Yeah. Yes. Correct. No
That-
private cause of
okay.
action created under the bill.
Earlier, and they're adding more expansiveness to it, and we're gonna make a decision on this after learning about it in like 2 minutes. Huh? Yeah. Welcome to Sine Die. When bad bills get moved.
Well, we have to discuss it after that.
We're gonna get it out of the morning.
Well, it's fine. Well, we'll discuss the bill when it gets out of rules. If it gets out of rules.
We did this last session, so we can do it. So let's,
Okay.
all right,
You explain
And it's-
what the bill does and then you favor.
since I could.
I'd rather. Procedure available for members to not move it until we see it out of rules. Like, I don't think it's right for us to move something that is this expansive without having it written in front of us. Regardless of the intent of it, we don't have anything in writing that shows us this. And I have a problem with that. That is an affront to democracy. We cannot be moving things without having the language in front of us for
Yeah,
transparency.
You can say that. You could pull the bill up on the floor system.
Have a motion on the floor.
What number is it?
We're discussing the motion.
What number is it? 47. HB 947. 9.
So I don't see why we can't just undo it on the floor. I just think that on Saturday, the work of this committee was undone right on the floor. And I think we ought to do the exact same thing on this one. If it's gonna be necessary, if it comes out of rules, then it'll be on the floor. Why should we have our fingerprints on? Well, we don't know yet because we don't have it in front of us.
See, right now.
Except that it has not been passed out of rules
We did that last year.
or third reader on the floor.
Oh. Well, I think I'm in agreement with Senator Muse and Senator Waldstreicher on this. We have the language in front of us. The motion was to move it preemptively. We have the language. I'm worried about timing. We know that it's sine die. So my thought is that we are perfectly capable of looking at the language we have before us and making that decision. The only thing I was saying about the floor was if something comes up because we haven't enough time, there's still time to amend a bill on the floor if there's concerns that Senator Folden has that he hasn't had time to address yet. And we did do that pretty massively the other day.
Absolutely. All right. Let's hold while get a printed copy. We'll move forward with voting and we'll come right back to this. All right, can you print? I got it. All right, thank you. Let's go to Josh with House Bill
I just printed it.
193.
House Bill 193 authorizes Anne Arundel County and municipalities within the county to decrease the maximum speed limit to no less than 15 miles per hour on a highway after performing an engineering and traffic investigation. However, the county may not implement a new speed monitoring system on any portion of a highway for which the speed limit has been decreased pursuant to this authorization.
Give Senator Fulton a second. Yeah. Good. All right, let's go back to House Bill 193. You're okay? All right. Guys, all right, the motion is favorable for House Bill 193. It's been seconded. Everyone is okay. You're down on it. All right, hold on. Wait for a second. Hold on.
Okay, thanks.
All right, can you all just 1 second here? We just passed House Bill 193.
Yeah, I got it.
Okay, Senator Fulton is down.
Okay.
Senator McKay is down. Sorry, Senator. No, that's not that bill. Yeah. It's a. Okay. Let's slow things down a little bit so everyone understands what we're doing. Okay. Yeah. Oh, good one. All right, we're now going to go on to House Bill 840.
Bill 840, I'm hearing from my friends over on the Judiciary Committee on Delegate Woods' bill, which is a conference committee I know is very important to a lot of us. It's Delegate Kaufman, Delegate Valentine, and Nicole Williams is the chair of the conference committee. So it sounds like that's been worked out. We'll just make sure the paperwork gets moved along with them. This is on a Delegate Woods' bill for the wellness checks that you had the cross file of, Senator Muse.
All right, I'll get down.
Since
House Bill 840 specifies that all new vehicle dealers of Class M motorhomes and Class G trailers and any salespersons may participate in 3 annual vehicle shows. Further, the bills do not have to be limited to Class M or Class G vehicles.
Motion's for favorable has been seconded. Is everyone okay being recorded in the affirmative for House Bill 840?
Yes.
Okay, House Bill 840 passes unanimously. We'll now go on to House Bill 1065. That's Jamie.
House Bill 1065 establishes the Maryland Entertainment District Security Grant Program to assist community organizations, nonprofit entities, and local governments to fund security operations during times of high pedestrian traffic in entertainment districts from which a higher than average number of calls for police assistance in response to reported crime are placed, and the Maryland Entertainment District Security Grant Program Fund as a special fund administered by GOCAP. Beginning in fiscal 26, the governor may annually appropriate up to $1 million to the fund. The bill
She's giving out again.
does include the same provision that this committee and the Senate added to the Senate cross file, including high density establishments of hookah bars.
That was my only question. Did they have the hookah amendment? And they did. All right. That's right. All right. Motions for favorable. Second. Is everyone okay being recorded in the affirmative? I know the delegate is texting me as well. I understand. We are going to get to it. Let's go to House Bill 690. That's Shamari.
House Bill 690 alters the membership of the Adult Protective Services Review Board in Charles County to authorize the appointment of a physician's assistant or nurse practitioner in the field of psychiatry to serve on the board instead of a psychiatrist.
Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? House Bill 690 passes unanimously. All right, we're gonna go to House Bill 737.
House Bill 737 requires a driver traveling slower than the general speed of traffic on any roadway rather than just an interstate highway in a rural area to drive in the right-hand lane or lanes if the driver determines it is practicable.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Except no fines.
And no, exactly. And no Neil. I loved it.
And no, that's good. There isn't.
That's harassment.
Not enforceable.
Not enforceable. Not again, we stop. So.
House Bill 321.
House Bill 321 prohibits a person from committing a crime of malicious or fraudulent burning that causes the death of or serious physical injury to a firefighter. A violator is guilty of a felony and subject to imprisonment for up to 10 years. A sentence imposed for a violation of the bill's prohibition may be separate from and run consecutive to or concurrent with a sentence imposed for any crime based on the act establishing the violation. The violations of law that are covered are malicious burning of personal property in the first degree, malicious burning of personal property in the second degree, or burning with intent to defraud. So the question was about the causation requirements, how related would the act of arson or malicious burning need to be with respect to causing the death. As the bill originally came in, it covered a firefighter who died during the response to the fire or efforts to suppress the fire. I believe some concern had been expressed about just whether that actually needed to be at the scene, if it needed to be, or if it could be somebody died in traffic on their way to the scene. So those provisions were struck. I do want to note, just for clarity, that if you're looking at page 2, the new prohibition would say that a person may not commit a crime of malicious or fraudulent burning that causes death of or serious physical injury to a firefighter. It doesn't, again, really say how direct that cause needs to be, but I just flagged that for the committee. Right. It doesn't use the word direct. What it does say is that a person may not commit the crime of malicious or fraudulent burning that causes the death or serious physical injury of a firefighter. So it doesn't say that it needs to be the direct cause, but it just says that you would need to show some causation.
Motion's for a favorable. It's been seconded. All right, is everyone okay being recorded in the affirmative? Okay.
About and make a determination. That's what I think.
Yeah. Well, at least. I mean, look, the words direct are not there, but I think it's the intent of it to narrow this down so that there's more of a direct correlation. And not so broad.
This is not take the plan where you're going.
I know. Senator Fulton, go ahead.
Motion to reconsider the vote so I can just ask about it.
You can do that if you like.
Yeah, I want to make a motion to reconsider the vote so that we can have the discussion just a hair further, because I just understand and see the nuances that I have concerns of.
Is that's okay? Now the bill's before you.
So to be clear, when we're talking about malicious or fraudulent burning, and it causes the death or serious injury to a firefighter, it's been struck out. Correct me if I'm wrong here, but in the version I have, it's been struck out: response to the fire or efforts to suppress the fire, which would have tightened it a little bit more. But now, or at least the efforts to suppress the fire, because there have been unfortunate circumstances where firefighters have had a brush fire that may have been set, or whatever the circumstance, but a brush fire that was set by young kids out in a field, and during the response, a firefighter gets out of the truck and he has a heart attack and he dies. According to this bill, that would be a 10-year felony. Is that correct? Even though it was not a direct causation from the fire, it was during the response to the fire. I mean, I'm just asking, is that correct?
Well, so no, because the specific question of response to the fire was struck. You need to demonstrate in order to prove the offense some causation. So let me read you the offense. If I don't know if you're looking at the amended language. Yeah, it's House Bill 321, Senator. And if you look at text, if you're in your floor system, it's under text for third reader. So if you go down to page 2, lines 5 through 7, a person may not commit a crime of malicious or fraudulent burning that causes the death or serious physical injury to a firefighter. So the state would need to demonstrate some causation there. It wouldn't be sufficient to say that, because it was during the response to the fire that there was a heart attack, just because it was in response, that is conclusive that the person's guilty of the offense. I really can't tell you how much causation is necessary, though, in order to get a conviction. Now, I will say, I spoke with Mr. Kroll about this from the State's Attorneys Association. It was his view that solved the issue. I don't know that I would necessarily agree. I think you could read it multiple ways.
So the first response was that no, you didn't feel that would be something that would be attached to, could be construed as being a direct, because it doesn't say, it just says a person may not commit a crime of malicious or fraudulent burning that causes the death or serious injury to a firefighter. The reason I bring this up is I can tell you that under the National Firefighters Association and their memorial, the response to a fire or incident, any incident, and a firefighter suffers a heart attack and dies, expires on the scene, that is a direct causation from that, and their family are entitled to benefits thereof.
Sure. And I think when I heard you say response to the fire, I was just thinking that the House had struck the specific language in the bill that said response to the fire.
They struck that out, and that's fine. But the efforts to suppress the fire,
right? And I think
why is that struck? Because that's what it really should be focused on. Would be the actual efforts of an individual to suppress a fire who suffers serious or bodily injury. That would be much better, I would think. So
I think that maybe the more appropriate answer to your question is it would be subject to interpretation about whether or not it would qualify, or it could be subject.
Well, that's what my concern is when we have something like this that's left open, subject to interpretation. I mean, we could start an Attorney General's fire investigator division. They could look at it through their lens. I'm just kidding. So just kidding, that'll be coming next year. Kinda. So
I just wanted to understand what anyway from the House, that removing 1 and 2 under B, does that make the bill broader, less restrictive, or what was the intent of that? Because without any language, I'm very confused as to how to read that. But what were they trying to do to
so
best
again,
you understand it?
I sort of based this on my conversation with Mr. Kroll.
Yeah.
As far as I had not had any discussions with anybody, in the House, or even watched any of the discussions in committee or the floor. But my understanding in what was communicated to me was that it was an intent to narrow it, so that it wouldn't be the case that somebody who was responding from say they were on the highway and there was a traffic collision as the truck was responding to the scene,
Right.
that scenario would not qualify under the statute.
And why did they, I mean, I would think you would want to protect firemen in the line of duty, if you will, right? Or at least make that a crime. So why did they feel they wanted to narrow it? I mean, I think, I just don't understand what they're trying to do with this language. But you say the state's attorneys are satisfied with this language, that it will allow them to prosecute people for malicious fraudulent burning that causes a death. But the cause of a death is really ambiguous in my opinion, but anyway, they'll have to fight that out in court. Or in a motions pleading and see what the judge does with that.
All favorable committee testimony originally they were in favor of it, the way it was written. I don't think it's fair to say we have an answer. Are they okay now with the change? Even though I think they are, but obviously I'm not them and I don't want to speak for them. That is correct. So that was professional, volunteer, then state's attorneys, from there's about 5 different state's attorneys that were all in favor of it when it originally came in. Well, that's what I'm saying. I think they were, and if they had a problem with it, they probably would have said favorable with amendments. And according to Chief Phillips, with fire EMS, they're okay with it. So
Okay.
I
They're
don't want to
okay
speak
with
on, I don't want to speak on behalf of
I
somebody.
know, all right.
I understand we have to move on. It's always difficult when we get down to the wire like this. Well, my intent in asking a question further, it was reopened. I was probably gonna be quiet and let it go, but I had questions and, there's not enough time to dig out the books. I know that we have similar but not exact kinds of laws we've passed, and the ones I can think most closely resemble this are the reckless driving where a death occurs and we have an additional penalty. We don't have a separate felony though. Think this is different. So my question to council is there any other area of the law, criminal law, where we do something similar and where causation in this type of instance has been defined in a criminal matter, not civil?
That, Senator, I'd maybe look through the statutes. I don't think I could give you
Because we know that in
like,
civil and negligence that we know what proximate cause is. Is that something that we would want to do here?
right. And I guess the question would be is first, if there is an analogous offense that I could find for you, how have courts interpreted causation to apply, and how direct of a cause it needs to be, or how attenuated of a cause could it be? I just don't have that answer without additional research.
Senator Sidor, then.
I'm fine now.
I just have, Jamie, in any other criminal statute, does the statute use the word cause without the word being modified by directly or indirectly, or would this be brand new in Maryland's criminal statutes, or are there other cases of this happening?
Right, and I think that follows with the line of questions from Senator Carter just a moment ago, and the answer is I suspect I'll be looking on through the code to answer that question. I just don't have an answer for you right now.
Okay, so we're going to hold this, and you'll check while we're holding it.
947 for discussion. You got the interlineated copy before you. All right, I think you want to move, you said, Senator James, a quick question. There's a motion that's been seconded.
I may have missed this when we were
Yeah.
trying to describe the bill without the the amendments. I got that we added the Baltimore County and county solicitors and state's attorney. The only thing I wanted to ask about is on page 2, you'll see that they crossed out 2 sections, the definition of firearm accessory, and then firearm, what is it, line 26, possessed in the state. If it was reasonably foreseeable that possession would occur in the state. So if somebody could just, I think those are the only 2 changes we didn't talk about. We did.
We did that before sending.
Okay, thank you. That's very helpful.
I have to, which words?
No, I have one last question. It's probably no big deal, it's just a drafting issue. On page 5, now that we've sort of eliminated, private citizens to bring actions and we've limited to the attorney general and prosecutors, is it still correct to say a party seeking relief under this? Is that the right parlance? It's not, I don't think we should change. I'm just really caught my eye that I wasn't sure that's how we would describe it when we have limited it to, the AG and.
So,
But
I mean,
it could be, it may be right. I just was looking for consistency.
I mean, I think that's right. I think it's actually more appropriate now that we've added the county attorneys and
Yeah.
the city solicitor. So
Now it makes a little more
it
sense.
makes,
to
it
leave
makes
like-
even more sense now, I think.
Yeah, all right, thank you.
So. I'm sorry, was somebody else? Oh. So we got the one copy and then this one is the 5-page one. It's the correct one we're supposed to be working from. So on this one, it's struck out that firearm accessory has been struck out, which was one of the concerns, right? We struck that out. Okay, but my concern is we have a firearm related product. So was that added in since the original line, the original version? Because ammunition or a component or part of a firearm or a firearm accessory, which we just struck out firearm accessory in paragraph C, but it's in the language under paragraph D.
We voted it out of the Senate.
I understand, Senator. I'm just asking because we have a definition of a firearm accessory in paragraph C. Or I'm sorry, we struck out the old paragraph C, we struck out firearm accessory in the definition. We have a new C, and then under D, it talks about firearm related product. And then the last part of it means a firearm ammunition, a component or a part of a firearm or a firearm accessory. So did we strike it? Because it's still in there. But we specifically took out firearm accessory and the definition, but we put it back in a paragraph later. Or I just think that goes back to the whole issue that we were having. I mean, an accessory is the muzzle dust cap. It could be, you're talking literally anything, a sling, you're talking anything that doesn't relate to the actual operation of the weapon, but could actually be used for like a chamber block, which makes the weapon safe and makes it easily identifiable that it's safe. But by this bill would make it something that they could sue them over. I understand this bill wants to get moved. I get it, but it still leaves open the same concern under firearm accessory that we had all along, that we struck.
Yes, thank you. Thank you, Mr. Chair. So I don't see, and I guess I'm asking Jamie about this. I don't see anything in, excuse me. Oh, it's Shamari. I'm sorry, Shamari. Sorry. I don't see anything in here that's Maryland centric. So as I read this amendment, it would permit, for example, the county attorney of Montgomery County to file suit against a gun shop in Montana for problems that the gun shop in Montana has created in Montana. Is that correct? No? No, they go to Montana. And do it. They could do it.
So in order to file against the gun industry member in Montana, the harm would have to be felt within wherever that county attorney's jurisdiction is. And so I think they wouldn't be able to file for anything happening in Montana. It would be, limited to their county.
Okay, so but it would allow a Montgomery County county attorney to file suit against a gun manufacturer in Nebraska whose gun made its way into Maryland by some circuitous route for damage caused by the gun manufactured in Nebraska that has created damage here in Maryland.
If it was a public nuisance, then I think that's a fair reading.
Okay, thank you.
Damage. Doesn't have to be in a plaintiff. They can do it on their own. They can assume it. They don't have to have a witness. So it's even more open-ended. Okay, for this to become political.
Yep. Yes.
Yes, I don't. I didn't understand.
Yes, the vote. The bill's gonna.
So it's not gonna, we're not taking that. Okay.
Okay.
All right.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
No,
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
No,
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Oh,
Senator Carter. Yes. Chairman Smith.
Yes. House Bill 947 passes 7-4. That'll conclude our voting session. We passed it? 106. What was the cross all again? I have it written.
maybe find out who's there.
Did House Bill 1063?